Welcome to Casa Academy Chapter 8, Part 3, where we will cover property rights, estates, and tenancies. I am literally so thrilled you're joining me today because we're going to take concepts that often feel, a bit tangled up and lay them out clearly and logically.
For the really focused learners out there, consider this explainer your ultimate study tool. We are going to completely demystify real property ownership concepts right here, right now. We'll use this information to build your foundational knowledge and help you absolutely ace your Florida real estate exam. No fluff, no distractions, just the critical information you need to succeed.
So, here is our agenda for today. We're going to start with an introduction to property rights, move into fee simple types, and then discuss co-ownership concepts. From there, we'll cover life estates, reversion versus remainder, and wrap a whole shebang up with exam question mastery. Section 1. Introduction to property rights. Understanding the basics.
Right, so before we can talk about the different flavors of ownership, we have to establish the absolute baseline of what property ownership actually means under the law. We'll be using a deductive structure for this explainer, starting broad and filtering down into the very specific variations. An estate, actually scratch that, you'll also hear it called a tenancy on the test, defines the degree, quantity, nature, and extent of a person's ownership interest in real property. Simply put, it defines your rights. Now, here is an absolutely crucial point that trips up a lot of test takers. In property law, a tenant doesn't just mean a renter holding a lease. A tenant is anyone who holds rights in real property.
Okay, let's dive into this. When you hold an estate, you hold certain rights, and this is commonly known as the bundle of rights. Think of it literally like a giant bundle of sticks, right? Each stick represents a specific legal privilege. You've got possession, disposition, enjoyment, exclusion, and control. Now, depending on the type of ownership you have, you might hold this entire bundle all by yourself, or you might share these sticks with other people.
Section 2. Fee simple types. Complete ownership forms. In real estate, there are two main categories of estates, freehold and non-freehold. For the purpose of this explainer, we're going to put our blinders on and focus entirely on freehold estates because they're the absolute cornerstone of property ownership. If you own a piece of property, you have a freehold estate. The defining characteristic here is that it involves actual ownership and generally has no fixed expiration date. It's not ticking down like a lease. Within this broad category, there are two primary types we really need to master: fee simple estates and life estates. We'll start off with the fee simple estate. When you see this pop up on your exam, immediately remember that it's the most complete form of ownership possible. It's also by far the most common type of ownership you're going to encounter out there in real estate. The owner holds the absolute complete bundle of rights, they've got every single stick, and they have the greatest degree of control over the property. But you might be wondering, how exactly do you hold that title? Well, there are 4 common ways, and we'll look at the first one right now. The first way to hold a fee simple estate is an estate in severalty. Now, I know the word severalty sounds kind of like several, which might make you think of multiple people, right? But it actually means the exact opposite. It means the ownership is literally severed or cut off from all other owners. It exists when one individual owns the property completely alone. They hold the entire bundle of rights all to themselves, and importantly, when that single owner dies, their ownership interest passes directly to their heirs. Section 3. Co-ownership concepts. Sharing property rights. So what happens when ownership isn't severed, but it's shared? That leads us perfectly into exploring co-ownership and a really vital legal concept known as survivorship. Now, what's really interesting about this slide is how it clearly draws the battle lines between the two most common forms of co-ownership. First up, we have tenancy in common. Here, owners can actually have unequal shares. Say, one person owns 75% and the other owns 25%. Yet, they all share an undivided interest in possessing the whole property. Most importantly, in a tenancy in common, if an owner dies, their specific share goes to their heirs. On the flip side, we have joint tenancy, which requires strict equality. And the biggest difference, joint tenancy features the right of survivorship, meaning if an owner dies, their heirs get absolutely nothing. The share goes directly to the surviving co-owners. No way around it.
Because joint tenancy is so strict, it actually requires 4 specific unities to be created. Please memorize this acronym: PIT. Possession, interest, time, and title. All owners must have equal rights of possession, equal interests, acquire title at the exact same time, and on the same deed. To illustrate just how powerful the right of survivorship is, let's look at an example from our source material. Imagine a property record identified as file number 500125 showing 3 joint tenants.
If one of those owners passes away, their interest automatically and immediately transfers to the remaining 2 joint tenants. The deceased will doesn't matter here at all. The surviving owners just absorb that share instantly.
The final type of fee simple co-ownership is tenancy by the intricacies. This one is extremely specific. It's a special form of ownership available only to married couples. Under this arrangement, the law doesn't view it as 2 separate people owning a property. It treats the marriage itself as a single ownership unit. Like joint tenancy, it includes the right of survivorship. If one spouse passes away, the surviving spouse automatically becomes the sole owner. Oh, and as a quick note for your course records, your verification code is 988884. Now, what happens if the marriage ends in divorce? Well, the legal unit is broken, so the tenancy by the intricacies is typically automatically converted right back into a standard tenancy in common.
Section 4. Life estates. Ownership for a lifetime.
Let's transition away from fee simple estates for a second and look at the second major category of freehold estates. A life estate is, well, it's exactly what it sounds like. It's created when ownership rights are granted to a person for the duration of a specified lifetime. The person holding these rights is called the life tenant. They get to enjoy possession and use of the property, though some of their rights might be limited. A highly practical example of this is a parent who transfers the ownership of their home to their children, but legally retains the right to live in and control that property until they pass away. In this scenario, the parent is acting as the life tenant.
Section 5. Reversion versus remainder. After the life estate.
But that begs a very obvious question, doesn't it? What actually happens to the property the absolute second the life tenant passes away? And this brilliantly illustrates our 2 possible outcomes. First, we have a reversion estate. Think of the word reverse. It goes backward. Ownership returns straight to the original grantor who created the life estate. Second, we have a remainder estate. In this scenario, ownership moves forward, passing to someone other than the original grantor. These lucky future owners are called remainder men. So if a grantor gives a life estate to a relative and specifies the property goes to the relative's kids afterward, those kids hold a remainder estate.
Section 6. Exam Question Mastery. Strategies for Success. Wow, we've covered a tremendous amount of ground today, right? From the bundle of rights to the intricacies of life estates. So let's wrap up this entire life cycle of ownership concepts into an actionable exam strategy. The crucial takeaway is this. When you're sitting for your real estate exam and you encounter an estate question that seems perfectly designed to confuse you, just take a deep breath and apply this simple 2-question mental filter. First, ask yourself, what ownership rights does the person have right now? And second, what happens to those rights when the owner dies? Are they severable? Do they survive to a co-owner? Do they revert? If you can answer these 2 anchor questions, you can cut through the legal jargon and confidently identify any form of property ownership. It really makes you wonder, though, how much of our society's wealth and history is quietly dictated by these invisible, yet incredibly powerful rules of survivorship and remainder, doesn't it? Keep that in the back of your mind as you study, and for sure, you'll do fantastic.